The law is absolutely full of exceptions. Law school for most of you will be about first learning the structure of the general rules of the legal system, and then learning that all those rules have exceptions to deal fairly with special circumstances. For example, we've talked about a duty of loyalty, but to whom does a lawyer owe that duty when representing, say, a child whose parents are the ones who hired the lawyer and are paying the fee? Welcome again to the lecture series for Ethics in the Legal Environment. I'm your instructor, Roun McNeal, and in this unit of the course, we are covering some of the special quirks and differences of representing clients who are not individuals, or at least not competent, capable persons, or they are not in traditional situations. The bulk of this first lecture deals with lawyers who represent organizations rather than individuals, and all of the sticky wickets involved therein. Additionally, we will discuss the special circumstance of clients with diminished capacity, because if you recall our rule of treating the client as principal, who controls the objectives of the representation, you will understand how it might be difficult to adhere to that rule if the client is not competent to make decisions. So in both of these lectures, you should think about these issues in terms of how to most clearly adhere to the foundational ethics of law practice in circumstances that seem to defy adherence to ethical rules. First, let's examine how to maintain ethical foundations when the client is an organization rather than an individual. Think of these issues first by considering a few questions. If a lawyer represents an organization, such as a corporation or a nonprofit, to whom does the lawyer owe her duties of loyalty, duty of confidence? Does she owe them to the president of the corporation, to the CEO, the board of trustees, all of the employees? Lawyers who represent organizations typically think in terms of answering to what's called a control group of executives or officers who deal with the attorney on a regular basis. This control group should be established and defined. The attorney and the officers of the organization should know who is part of this group. There should not be much, if any, guesswork about who in the organization has the authority to speak for the organization. This does not mean that the lawyer owes duties only to members of the control group. The duties, to be clear, are owed to the organization, which practically means that duties are applied to people outside of the control group. A lawyer's duty of confidentiality, for example, extends beyond the control group and attaches to communications between the attorney and individuals seeking counsel within the scope of their employment. So if an employee outside the control group reveals information to the attorney that is a communication within the scope of that employee's job, that information is confidential, and the attorney owes a duty to the organization not to disclose that information outside the organization. Think as we continue the lecture about how to deal with disclosing information within the organization. How does the lawyer decide who within the organization needs to know confidential information shared with the attorney by an employee? In Upjohn Company versus United States in 1981, the Supreme Court made clear that the duties and privileges owed to the organization extend beyond the control group. Prior to the Upjohn case, the law indicated that communication between a lawyer for the organization and mid-level or lower-level employees were not protected by attorney-client privilege. Only communications between the attorney and the control group were entitled to the privilege. Upjohn changed this thinking. The facts are these. Auditors for the Upjohn Company alerted Upjohn's management that some subsidiaries of the company were making improper payments to foreign government officials. Based on these audit findings, the lawyers for Upjohn conducted an internal review. The company then authorized the lawyers to disclose some of these payments to the federal government, but the disclosure was limited. Federal prosecutors thought that there might be more, and so they sent a subpoena for all of the lawyers' notes from those internal investigations. The company claimed that those notes and the communications contained in them from middle and lower level employees of the company were protected by attorney-client privilege. The government's position was that only communications between the attorney and the control group were protected. The Supreme Court disagreed with the government, saying middle-level and indeed lower-level employees have the relevant information needed by corporate counsel if he is adequately to advise the client with respect to such actual or potential legal difficulties. Essentially, the control group would not be able to protect the interests of the company without protected, unmolested communication between the attorney and the employees of the company. This prompted a new way to think about how to view confidentiality within an organization. Now we think of confidentiality as being linked to the substance of the communication rather than to the person who made the statement. Lower-level employee statements that are made in the course and scope of their job as part of representing the company to which the lawyer owes the duties of confidentiality and loyalty, those communications are protected because of the substance of the statements, not based on the employee's membership or non-membership in the management structure of the company. Lawyers who are operating in an organizational structure must be clear about who they are representing so that they can determine to whom they owe loyalty. There's a difference between being the lawyer for the company and being the lawyer for the president of the company. Let's think of a hypothetical. Imagine an attorney who is asked to serve on the board of his local church. Is the preacher or the parish his client? Are the members of the board his clients? Are any of them his clients? Does he owe any duty if he is just a board member, not specifically having been retained as counsel? Or think of situations where attorneys represent corporations that have wholly owned subsidiaries. It may be infrequent, but it's not impossible for the interests of the parent corporation to be at odds with the interests of the subsidiary. In a situation where there are conflicts between the organization or within the broader organizational structure, a lawyer must be clear about whom he actually represents and to whom he owes fiduciary duties. A lawyer has to be diligent to keep his primary obligations to his client, the organization, central to his decision-making. When talking about the corporate and organizational law, we call groups of individuals that are part of the organization constituents. That's a vocabulary word to learn. Constituents can include a subsidiary company, an employee, a trustee or director, even the CEO. Distinguishing between the organization and constituents of the organization when it comes to duties can get tricky. Imagine, though, if a constituent entity, let's say the CEO, disclosed information to the lawyer which, if kept secret, would harm the organization. In this situation, the lawyer's duty of loyalty belongs to the organization. So he would be required to disclose these secrets that the CEO told him in confidence. There is some gray area, though. The best interests of the organization might require that the lawyer attempt to mitigate the situation without disclosing. Here's another hypothetical. If the CEO tells the attorney that he is planning on selling the corporate plane for pennies on the dollar and instructs the attorney not to tell anyone, the lawyer has to think about the best interests of the company. The attorney knows that selling off an expensive asset for a small amount of money is bad for the company, and that the board of directors would object. The lawyer should also know that this situation is bound to create conflict, and that conflict is usually bad for business. So a lawyer, conscious of the best interests of the organization, might first attempt to mitigate the situation, advise the CEO not to proceed unilaterally, and then, if the CEO insists, the lawyer could inform the board of directors. Because the lawyer owes duties to the organization, there are circumstances where the lawyer may be permitted to disclose information or communications that, if the organization were treated exactly like an individual client, would violate confidentiality. Sometimes, for example, it is not just the CEO that may be acting foolishly, but perhaps all of upper management is acting outside the best interests of the company. Especially when talking about publicly traded companies where ownership is distributed across many people, an attorney who recognizes that management is clearly acting in a way that threatens the company may have a duty to notify proper authorities. If management is acting outside the law, the lawyer has an obligation to report clear violations of the law or other acts or omissions to prevent reasonably certain and substantial harm to the organization. In thinking about violations of the law by officers of the company, you ought to be thinking about the lawyer's duty of loyalty to the organization, as well as the crime-fraud exception to the duty of confidentiality. These disclosures, however, can create obvious friction between the lawyer with the duty of loyalty to the organization and the officers of that organization who are not pleased about the disclosure. For this reason, lawyers are afforded certain legal protections when they make permitted or required disclosures in the best interest of the organization and in the service of their first loyalty to justice. First, lawyers who make disclosures as part of their ethical obligations to the organization are protected against retaliatory discharge. A client's firing of an attorney for the attorney's failure to pursue the client's unethical or imprudent course in handling legal matters is known as retaliatory discharge. And lawyers may be entitled to money damages if they are fired for required disclosures or for other adherence to ethical rules. The law also recognizes the concept of constructive discharge, a scenario where the lawyer isn't fired but stops working for the organization due to the client's insistence on pursuing unethical or imprudent means to achieve its desired result in the legal matter. Consider the facts in O'Brien v. Stolt-Nielsen Transportation. Paul O'Brien served as general counsel for Stolt-Nielsen Transportation and claimed that he was forced to resign in 2002 after discovering that top executives were engaged in price fixing. O'Brien alleged that after discovering the criminal conduct, he demanded that the parties cease. When the company executives would not end the criminal price fixing, O'Brien resigned because his continued employment would violate Rule 8.4 of the Rules of Professional Conduct. O'Brien sued his former employer and client, Stolt-Nielsen, for constructive discharge, and he won the case. Let's switch gears entirely and move away from the corporate world and toward vulnerable populations. The second special type of client I want to talk about in this lecture is the client with diminished capacity. Remember, the client is the principal. She owns the representation, and she directs the objectives of the representation. That does not change just because a client is incapable of fully understanding the legal situation. But it is more difficult to give the client full agency in making as many decisions as he is capable of making. We call this diminished capacity, or a client's inability to fully understand the legal ramifications of his decisions as a result of immaturity or of some mental or physical infirmity. Lawyers for clients with diminished capacity have to weigh the client's wishes against the client's best interests. The most difficult task is when the client takes a position that is not in her best interests, and the attorney must essentially disobey the client directive. How does a lawyer best combine the wishes and best interests of such a client? Well, it often involves, and may indeed only be possible by, consulting with another professional, such as a doctor or therapist, and also perhaps a family member or next friend of the client. Some clients are intellectually and emotionally sophisticated enough that a consult with the client, the lawyer, and family members will help the client to see and consult and consent to a course of action that is in his best interests. Other times that is not possible. Clients who are not capable of making decisions for themselves may become wards of a guardianship or a conservatorship. Guardians and conservatives are judicially appointed third parties who have the legal authority and fiduciary duty to care for a diminished person and or his property. These individuals are known as either guardians or conservators, depending upon the circumstances of the case. While the conservator or guardian may have authority to make the final decision for the client, the goal is to permit the client as much independence and dignity as possible. And even where guardianships and conservatorships exist, it is important for the lawyer to remember that his duty is to the client over and above the guardian or the conservator. Before seeking a judicially appointed guardian or conservator, there are less invasive and drastic possible solutions. As I mentioned, the first option may be to involve professionals, friends, or family members who can help the client make an informed and reasoned choice. If the client is competent, they may acknowledge their inability to make significant decisions and choose to execute a document transferring power of attorney to a trusted friend or family member. Power of attorney refers to a third party's delegated authority to make legal decisions for the person who grants that authority. But these documents are revocable, so they don't have the permanence of a guardianship or conservatorship. An attorney may also recognize that support services may be available that can improve the client's capacity to make reasoned decisions. An addict, for example, might be of diminished capacity while they are using, so one option may be for the lawyer to help the client find addiction recovery services that restore the client's capacity. It is important to remember that diminished capacity does not completely abrogate the lawyer's duties to that client. The duty of confidentiality must still be considered. For example, in consulting third parties, an attorney may only reveal client information that is necessary for assisting the attorney in making the best decisions for the client. And the attorney must continue to respect the client of diminished capacity. Consider this admonishment in re guardianship of Hocker. An adjudication of incompetency does not make the ward any less worthy of dignity or respect in the eyes of the law than a competent person. It is not okay to treat your duties of loyalty, confidentiality, or diligence as less important merely because a less competent person does not fully appreciate them. These are two special circumstances that do not obviate the duties that a lawyer owes to a client, but rather put them in a special and particular perspective for clients who are not typical individual clients. But there are other special circumstances that are less generalized, and we will cover them in the next lecture. So, until next time.